I ready. Everybody ready?
Yep.
All good.
Camera mics are on, you are good to go.
Great, thank you. It is 7 p.m. I'll call the January 27, 2025 Richmond Zoning Board of Review to order. First matter that we have on our agenda is the approval of minutes from October 28, 2024. Any issues with the meeting minutes from any members of the board?
No,
So
I'll make a motion, we approve the minutes of October 28, 20, where you going? No, 2024.
There's a motion
Okay.
and a second. All in favor?
Aye.
Aye, minutes are approved. That brings us to new business. Number one, the application of Jordan Carlson, care of Mancini Carter, requesting an appeal from a determination by the zoning enforcement office with the town of Richmond for the property at 0 Buttonwoods Road in Richmond, Rhode Island, tax assessor plat 4C lot 128. We received a correspondence from attorney John Mancini requesting that this matter be continued to the March date, which is March 24th, 2025. Apparently, they're going before the town council to see if these issues can be resolved. If there's no issues with respect to that continuance, is there a motion to continue to a date certain being March
This is
24th,
Polito.
2025?
Yeah, so we're gonna go to that, we're gonna go to that date certain so that there's no need for re-advertisement.
Do we have to open the public?
You should open the public
Okay.
meeting and continue it to the date certain on March 24th.
Perfect. We will, it's motion to open it. We go through the motion practice.
You can open it and then have a motion to continue to that date certain.
All right, so we'll open that public hearing. Is there a motion to continue to that date certain of March 24th, 2025?
Motion to move to date certain,
March.
24.
Great. Second, all in favor?
Aye.
Aye. That brings us to our next.
Hearing was opened.
Yes, the motion to continue, which was approved.
Not to do a public hearing. I did not get a motion for that. We don't
No,
need.
no, he opened it.
Okay, open, but no motion
And
required.
just for the record, if we could have Attorney Mancini's correspondence entered into the record, I think that would be good practice.
Thank you.
All right, that brings us to item 2, the application of Frederick Sindrich requesting an appeal from a determination by the zoning enforcement office with the town of Richmond for the property at 1120 Main Street in Richmond, Rhode Island, tax assessor's plat 4A lot 1-1. We have a number of folks here, counsel for the appellant.
Evening, Mr. Chairman, members of the board,
How are you?
Attorney Dane Ardente, for the record, attorney for Mr. Sinrich.
Great. I know we have counsel for our town official.
Michael Consolino, I'm the town prosecutor for the town, but tonight I'm acting as representative, legal counsel for the solicitor after the zoning office.
For as long as I've been on the board, which is 8-9 years now, I don't think we've had any appeals. Seen them in other forms, but just kind of give us a once over of the procedure tonight, what we need to know. I just want to make sure everybody's on the same page.
Oh, and Mr. Ardenti's gonna chime in if he.
I know he will, and I
Yeah, he
encourage
will.
you to.
If you think I've got something wrong on the facts, but thumbnail sketch, and then I'll give you a little procedure. So Mr. Sindrich requested a building permit to construct a second floor on the property in question, which is 1120 Main Street in Richmond, to be used for storage for his ongoing construction trades contractor business. Fair.
Right.
All right. And that request for permit was not granted. It wasn't denied, but he did not receive the permit. Mr. Sindrich then, through council, applied for a zoning determination as the request for the permit wasn't granted. He received the determination, timely took an appeal to the zoning board. So you are the local board of appeals this evening under the new law. And under that new law, you have the ability to affirm, reverse, or modify the decision or determination by Mr. Jordan, the zoning official. And you basically step into the shoes of the zoning official. You have the same power as he does at the time. So the applicable law under the statute, Rhode Island General, is 452664 regarding appeals. It says the following: an appeal to the zoning board of review from a decision of any other zoning enforcement agency or officer may be taken by an aggrieved party. So that would be Mr. Sindrich. The appeal shall be taken within a reasonable time, which he did, of the date of recording of the decision. The officer or agency from whom the appeal is taken shall immediately transmit to the zoning board the record, which I believe was done, but you'll hear about that. And then regarding your decision this evening, and that's pursuant to Rhode Island General Law 45-2468, entitled Appeals, Decisions and Records of Zoning Board of Review. In exercising your powers, the Zoning Board of Review may, so it's discretionary, may, in conformity with the provisions of this chapter, reverse or affirm wholly or partly, and may modify the order, requirement, decision, or determination appealed from, and may make any orders, requirements, decisions, or from whom the appeal was taken. So that's your authority. Those are the statutes. So you can affirm, you can reverse, you can modify in part, affirm in part. You have some good discretion there. And again, it's discretion.
Mr. Ardenti, anything to add? I'm trying to make things easy, make sure everybody's on the same page here. So while we're a little informal, I think it's helpful where we kind of lay out some of the ground rules here. Anything that Mr. Zangari missed?
I have nothing to add to what Mr. Zangari said, other than the fact that there's somewhat of a procedural timeline to appeals to the zoning board of the zoning determinations from the official. In order for us to appeal to you, we had to appeal it within 20 days. Depending on what happens here tonight, this is kind of the step along the chain if we were to have to appeal to Superior Court eventually. Hopefully it doesn't go beyond that. But in order to exhaust the administrative remedies, that's why we're here for you.
Okay. So the 10,000-foot view, there was an application for a zoning determination by Mr. Jordan. He made that decision. The applicant was aggrieved by that decision and now has appealed to this board, which stands in the shoes of Mr. Jordan to decide that issue.
A modification to that a little bit, and you may agree or disagree with me, but the review of Mr. Jordan's decision is a review based on the appropriateness of this. So it's not necessarily a stepping in the shoes of Mr. Jordan. Is Mr. Jordan's decision appropriate based on the law?
I don't have.
Right. Is there a distinction? It's basically.
I guess yeah, correct.
Okay. So there's no deference to Mr. Jordan. He doesn't get, if there's there's no tie goes to the runner. We're deciding.
No deference. Yes.
Okay. Great. All right. How do we want to proceed, Mr. Ardenti? Do you want to take the lead? How do you want to proceed here?
Absolutely. I'll kind of give a little bit of an overview and then kind of highlight the issues. So there are two different reviews that we need to look at here. One of them is Mr. Jordan's, and then the others is the planner. This is a little bit of a background to this. As you stated, this is an application. Well, it was a request to release the building permit for 1120 Main Street. Mr. Sindrich intended to make some modifications to the second floor to continue his use of a contractor storage facility to add more storage to the building. The building permit was merely for additional framing. When Mr. Sindrich submitted this permit request, this has gone a very long time with no activity occurring on the permit until I got involved. And then once I contacted the planner had discussed with us that she thought we had to go for development plan review. Just a little bit of background on the property. The property itself is an underlying general business zoning district property. The planner informed us that it's part of the Aquifer Overlay Subdistrict B. So part of the issue with that was the planner expressed that pursuant to the Aquifer Overlay District, this would need to go for development plan review and a special use permit. Just as a baseline to the zoning district for general business, had we not been in the Aquifer Overlay District, this would have been a permitted as of right use, not a special use permit. Part of the planner's assertion as to why we needed to do this was that it was a change in use. We specifically had informed the planner that this was not a change in use. This was a continuation of the use that Mr. Sindrich had been involved in since his purchase of the property in 17. The use has not changed at all. Under your use code, which is section 602 for construction, trade, and contractor, permitted as of right in a GB district, and it's defined as includes the business office and indoor or outdoor storage of equipment, vehicles, for a carpenter, electrician, plumber, stoneman, landscape contractor, excavator, or other contractor who works primarily at an offsite location. I'm sure the board is familiar with Mr. Sindrich's business, which is superstructure construction. This is
I'm actually not. What does he do?
We do all types of construction, residential, we do municipal. And I had it for 40 years in Rhode Island.
Can you
We
just
just wanna
state your name for the record?
Yeah, let's swear you in, Mr. Sindrich.
Fred Sindrich,
Good evening, sir. And we'll just swear you in for the record. You swear to tell the truth, the whole truth, and nothing but the truth here this evening?
absolutely, yes, I do.
Thank you, sir. And the question, I missed part of your answer. What do you?
I've been building in Rhode Island for 35 to 40 years. Constantly, I had a big building in South Kingston. We sold that. We bought this and immediately moved our equipment up there. Prior to my purchasing it, I met with the town, which at the time was Bo Brown. Let me get this. Juliana Berry and the guy, the building inspector at the time was temporary, Mr. St. Lawrence. We bought the building. I bought it from Woodmansey. I had a sales agreement. Sales agreement, stipulations that I had to get certain things approved, septic, you know, the whole deal. Bo said you're not going to get a permit until he was the planner at the time, until you have the septic, wetlands permit. You know, this costs a tremendous amount of money. I went through it. It took years to do, fully permitted. Then I went for the permit with the same set of plans. I don't know, Juliana's record should be in this building. And then we applied for the permit and they said, I got to go through looks like years more work. The building's been there since 1928. It's been used. There was a boat building, welding. It was a fabric place, all kinds of stuff. So I feel like it's a problem here with the zoning.
I mean, Mr. Ardente, I cut you off just to find out that bit of information, but please.
Yeah, no problem. And Mr. Stinrich is going to come back up after.
Yeah, and that's one thing I was gonna add. Let's make sure we have a
Yeah.
record here, but I don't want to stymie your overview because it's helping.
So back to what the planner had requested, he claimed that we needed to go through development plan review and obtain a special use permit under the Aquifer Overlay District. However, DPR is only required for the development of new principal uses and accessory uses, construction of all new structures permitted by right, or changes of use from one permitted use code to another permitted use code, and from non-conforming use to permitted use. That's section 18.21.060 of your code. I had expressed this to the planner and tried to be very clear with her on it. There was some disconnect, but this is not a change in use. It's just a continuation of the same use that Mr. Sindrich has been involved. Regarding this, so none of this triggered DPR under the very express terms of your guys' regulation, not original. Regarding the special use permit, the planner also claimed that we needed a special use permit based on it being located in Aquifer overlayers. I had pointed this out to the planner on multiple occasions, another thing that did not land, but recent changes to state law, and these went into effect in 2024, January 1st of 2020, is Rhode Island General Laws 45, 24, 42. This changes the requirements for special use permits. What it does is it establishes specific and objective criteria for the issuance of each category of special use permit, which criteria shall be in conformance with and purpose of the comprehensive plan and the zoning ordinance of the city and town. General Assembly has been extremely clear on this. If you require a special use permit, you have to have specific and objective criteria for that individual special use permit. So in other words, you can't have a category of special use permits under like an Aquifer overlay district and say, well, if it's in the Aquifer overlay, that's our special and objective criteria. It's not how it works. And the Rhode Island General Assembly changed it so where if an ordinance, and I'm reading this directly from the Rhode Island General Laws, if an ordinance does not expressly provide for specific and objective criteria for the issuance of a category of special use permit, such category shall be deemed to be permitted as of use. There is no special and objective criteria for this special use permit in the code. This is a permitted as of right use. Going to resort back to the base zoning district, which is general business, which contractor trade and storage is permitted as of right. The code provides, additionally, the planner said that that this would be considered a minor subdivision that would require a special use permit. Code provides minor subdivision and land development approval is required for any special use in the occupier zone, including enlargement of a legal non-conforming use. If the special use permit involves construction of a 7,500 square foot or less new commercial development, keyword new, an expansion of up to 50% of the existing floor area of the commercial use, or expansion of up to 10,000 square feet of the commercial structure. Richmond's code expressly dictates that this is not a minor land development. Additionally, a minor land development is defined in Richmond's code as a residential development consisting of between 2 and 5 dwelling units in one or more structure on one or more lots, which the applicant doesn't request waivers. That's Article 2 of the actual subdivision code. This is not a minor subdivision. First off, this is a commercial building, so automatically is cut out by the fact that minor is involved in residential. The zoning officer should have issued this zoning certificate and directed granting of this actual building permit based on these facts alone. Just to review, there is no specific and objective criteria for the special use permit. So automatically under the new state law, which I understand maybe under the old law, special use permits were a little bit more lax. Our General Assembly has been extremely clear. There's no specific and objective criteria. You cannot require the special use permit permitted as of right. This is not development plan review. It's merely an expansion of an existing permitted use in the zone. Not only is this simply a blatant and utter disregard for state law, and I understand that this isn't on the part of you guys, but here we are tonight reviewing this based on actions of the town. This is not only a blatant disregard for state law, but this law has been provided, and we provided it multiple times to the planner and Mr. Jordan. But this has resulted in the complete waste of the applicant's money, resources, time, and is perpetrated by town actors who frankly just want to disregard the state law. Again, I'm reading this from state law. We bring this appeal before you because it's not we're requesting this gets granted. Oh, we have a good argument for why this gets granted. This is law. This needs to be granted. And I welcome Mr. Zangari with any comments. I do have one inquiry, however. I am a little surprised. I've never seen a building official have his own counsel, separate from the council.
Yeah, I mean, for what it's worth, I have. I'm
Okay.
not sure it's worth anything.
I never feel that I've ever.
Anyways,
So any questions from me? I mean, as far as, how I got involved with this, and I was told one thing, and I diligently worked on it. I met with the state, the DEM, informally, formally. It took a year to do the wetlands permit. They had to count all the mice on the property, the whole night, everything. I got it.
How many?
Something like 1,000.
God bless you.
And they walked across a 2x4. So we did all that. We had a break. There was a question if there was water available there. There was town water. The water company wasn't the town water. The town owns the water, but if somebody managed it. So there was a question. So there was a curb stop there. So we got that all straightened out. We got the septic design built. Big septic system for one toilet, plus close to $60,000. That's done. Wetlands permit's almost done. We got to put the plants in May. I think we got to do it for the permit. And then we wanted to improve the building. And then I ran into all these stumbling blocks. So I did the same thing in South Kingston on 11,000 square foot building. That was a farm building. I was there for 20 years. By the way, I've never had a wetlands, DEM, or any kind of violation. We've had corrections on buildings from architects, building inspectors, but I've never seen the rules change when you're this far into the game.
Could you tell me what's there now, what the use has been in the past, and what your intent is to do in the future with that property?
The building was built as a textile mill. 17 something. This was an addition built in the 30s, 32, I believe. What they did in there, I don't know. From there, it operated its various things. They built one design boats for Westerly Yacht Club. They had one design sailboats, small ones. And then it became automobile repair, a couple different people. Wetlands, I mean, not wetlands, welding shop was the last use. We actually moved that guy out because he disappeared and all his stuff went to the scrapyard. When I bought it, it was being used as a welding shop. And that Wood Massey had no more use for it. So we saw it as a challenge. We found there was no pollution on the property. We did every test. So, and I met with the town on several occasions back before I parted with any money at all. Got all my permits, came in we got the septic built because we're very busy with our construction company. This is like a side thing. Septic built, got the water into the property, wetlands all, set up, ready to do. We were rebuilding the sluice gates, all the mill stuff from the 1700s for like a visual thing. And then I come to get the permits, and the planner especially gave me an extremely hard time. She wouldn't get on the phone to talk to me. She wouldn't meet with me. She wanted all the paper. I said, you have everything. The state has everything.
You have a structure. You want to make modifications to the second floor of that structure.
Right.
And prior to your request for modifications, what was the use in the second?
We
floor?
have it's storage now. We have built a few small things in there, but we're not set up. I put a new electric service on. I put a new roof on the existing building, but we're not set up there. We have other property in West Kingston where we live. This is my son Ivan. We have a 4,000 square foot barn there we work out of. That's complete. We have cows. We have all that stuff. We have 45 acres. So this is a commercial location. I'm not legal in South Kingston, by the way, because we're in a residential zone.
So it's storage. You applied for a building permit. Is it to
Storage.
change the use or just to
No change of use.
No,
It's
no
the same.
change in use.
just to modify
Yeah.
the second
We're
story?
not even putting the whole second floor. It's just a piece. I think it's 1/3, which brings it up to like 3,000 square feet. And it's, this could go on for the way this is set up with, especially with the planner, this could go on for 2 years. I mean, it's not right and I don't like it. So I was either you can review the letter she has. I had letters to the state about, if you give me the approval, go through the whole thing. If it's not approved, I'm not going to buy it. I'm going to leave. Somebody else will have to deal with it. But I did all my work. I spent all the money. Then I went as far as to build all the infrastructure. Now I just got to beautify the building. I don't know if you've been by there. We did the retaining walls. And we have like, I don't know, $20,000 worth of planting going in, satisfy the wetlands permit. But I'm not going to do anything more unless I can put the second floor on.
And just to be clear, the use proposed, which is part and parcel to and attached to the building permit, is the same use that's existing. It's just a modification of the actual framing in order to accommodate the storage in a better way. But
Moving walls around, is that what we're,
There's no increase in the footprint
okay.
at all.
Yeah.
Yes.
I don't think they know what it's. They seem to think the same.
Oh,
Second floor.
we're adding.
Oh, you're adding, okay, and that's it. Thank you. Ivan?
Yes.
Thank you. Okay. Any questions from other board members for this gentleman?
Sorry.
Oh,
Are
please.
you going up with the entire building?
No,
To
just
the
the
second
back,
floor?
just the back
The
portion.
back, little piece on the
I think
back?
it's 20, I don't know offhand, I think it's 20 feet. The building is how long, 60, 80,
60 something.
60 feet, we're putting 20. There's a wood frame part in the back, the front is brick.
Yeah,
We're going up on the wood frame, that's it, not the whole building.
yeah,
We try to make stuff look good,
yeah.
I pulled a permit to put a garage door and then this stuff happened. And I lost money on the garage door, $1,500 deposit, because the door was $9 grand. And I had a permit to put it up and then I said, I'm not putting any more money in this. We have a septic system there that's, like I said, I think it was 60,000 or because it was required because of the Wood River's right there. In the interim, this went to, the Wood River was deemed Waters of the United States of America. We had contact with them. They had nothing to do with it. You're all set, you're all set. So I'm 100%. My work was 100% done. I got stymied here by the planner. It's nuts what she did. So, I mean, what else? Any questions on that? Building's been there. It's gonna look better every day if I can't put any more money in. It's a lot of this stuff going on in Richmond. People are leaving every day in the business district. It's almost,
Yeah.
you know, we're in West Cason, we deal with the Walgreens. I got a letter today, they're gone. The other place left. Shopping center's empty. And then I'm trying to bring, we'll bring foot traffic, but there's gonna be nowhere for people to go. Why would you even come to Main Street in Richmond? There's nothing to do. 2 pizza joints and a bar. It used to be different. So we have plenty of other land. We can go somewhere else. But law's the law. I go by reading the zoning book when I get involved with purchasing a piece of property. If it meets everything in the book, you can do it. That's what I had with Bo and Juliana. That's it. Right?
Any other questions for this gentleman? Mr. Ardenti?
So just in sum, our request would be the reversal of Mr. Jordan's determination based on the fact that special use permit doesn't have specific and objective criteria to be an actual special use permit under the new state law. And development plan review is not required because this doesn't fit into any category required that development plan review triggered by. I understand a lot of things were said here tonight and there was a lot of information. The applicant, as he had stated, wants to work with the town. So that's why we're here before you, trying to work this out as amicably as we can.
Sure.
That's all we have.
So to the DPR and special use permit, yeah, the special use permit issue, and this is inappropriate, but I'm gonna say it anyway. I think since I've been on the board, we've said no once for in years and years and years. Is there an avenue by which it's determined that DPR is not appropriate, but the applicant simply needs a special use permit?
Well, so let me back up 1 second, and then I understand what you're saying. I just want to correct a little clarification on the state law. I understand that special use permits are rarely denied, even under the old law. I don't.
Depends on where you are.
I don't think I've ever seen one denied personally. The issue is not of the approval or denial. The issue is if there is no objective and specific criteria in the code, you cannot make someone get a special use permit for even applying. That special use permit is essentially cut. So what we've been doing, because I work with a lot of other towns and trying to revise their zoning codes with my firm. We just recently did Central Falls and West Warwick. I'm actually the zoning and planning board attorney for Central Falls. What we ended up doing was going through the table and figuring out, we would take all the special use permits, and there might be, 25 of them, and say, all right, which ones do not need to be special use? And if you really want to keep one as special use, you have to assign specific and objective criteria to it. Because then what happens if you don't, it just turns into a permitted use.
So in a use table, again, I'll take your example where there's a number of special use permits.
Mhm.
For each of those, let's say it's a gas station.
Yep.
There should be specific criteria for a gas station in granting that special use permit.
Correct. So like an example of this would be, I just did one in North Providence, which did have the correct specific and objective criteria. It was in the RG zone, it was like RG5, or I can't remember exactly what it was, but you needed a special use permit if you wanted to build 2 family structures, and you needed, it was like 8,500 square feet on the lot rather than 5,000, which is the permitted as of right. That's considered permissible specific and objective criteria. But you can't just assign an overlay district. Okay, everything in the overlay now is subject to the special use permit.
Okay.
If that makes sense.
Yeah, I think so. We have a number of parties here. Procedurally, how do we want to proceed? I know we have Mr. Jordan represented by counsel. The board has asked a number of questions of the appellant. Mr. Cozzolino, do you have any questions of the appellant? Put some testimony on the record.
The only issue that I had that zoning office brought up to me was when this, going back to the issue with the town planner, I know she had really initially determined this to be a change to a mixed use, if I'm not mistaken.
Mhm.
Was it originally proposed that there was gonna be an apartment upstairs?
That was the plan originally when I bought it, if you want me to get up. My son does custom hot rod. He rents a shop in Westerly, he pays $1,500 a month. So if we didn't use that for our business, we would put him in there, which is legal under the zoning ordinance, live workspace, right in your book. Perfect. He does beautiful custom work. One of his cars was just in Vegas, can't afford to do it because people rebuild cars, they do the body, they do the engine, they do the wheels, nobody can afford to do the interior. He does them by hand, whatever. So that was the first thought. And then Julie's dead lady, Julie said I was gonna open a restaurant, not Julie, whoever the current zoning is. She said, it looks like you're gonna open a restaurant, you got that big patio. Like, lady, she wouldn't talk to me, by the way. This is all in the emails. The patio is a loading dock that was built in 1938. We have a permit to rebuild it because it's cracked and it's a trip hazard. And that's that. I mean, everybody else in town's been good. She actually said, I don't think she knows how to read a plan. Never met her, never saw her. So yeah, we were gonna do that. And we may come back later and try and do that. Because if you read the zoning book, and I'm a developer, builder, like I said, no violations, we're by the book. It's right in there, live workspace. It's all over the state. There's a housing need. I want to buy a house out in Arcadia where my son, he lives in there now. And I gotta pay because I gotta pay more. I gotta pay part of the bills because he can't afford a place to live. So that's where he is now.
Okay.
I may come back to you and say, look, but we withdrew all that and we put in, that thing had a set of stairs, the apartment outside. And she said, well, you need, blah, blah, blah. I took all that off. We're not expanding the footprint. Everything's inside. Boom, it's all by the code. It's legal, right? Aquifer recharge area has been there forever. I can see from the loading dock there, the state has a 10,000 gallon diesel fuel tank sitting right across the river. I mean, come on, what?
No, I was just trying to, in my mind, understand how she could make the leap from what you were doing to calling it a mixed use, but that kind of made sense. Originally,
No, no,
if
no,
she
no,
had
no,
tried
no.
to do an
No,
apartment,
no,
maybe
no,
that
no,
could have
I
been.
changed everything.
Yeah, okay, all right.
I changed it and we
pulled.
pulled, she's an internet tough guy.
Yeah.
We pulled everything out, all the permit stuff, reapplied with a different set of drawings, which again, another expense. No expansion of the footprint. No change of use at all done. So we can do something with it. Now, when we do get the permit, we may not have the time to do it. We were slow at the time. So I don't know what to do.
Well, that's fine, I'm just trying to separate out the planning issues, which are not really before the board. The way I see it and represent the zoning office at this point, whatever the planning office is recommending or demanding is really not before you tonight. I think the sole issue before you tonight is whether or not the zoning office made a proper determination as to whether, under the facts of what was submitted, a special use permit would be required or not.
Right.
I mean, I know there's been a lot of said about the planner. I know
Yeah.
you've had some issues with her, but
Not
I
an
think
issue.
that's
She's typically with a planner, and to cut you off, I would go in any town, all the way to Woonsocket. We'd have a meeting, we'd discuss it, we'd figure out what to do, what's needed, what I would need, and I would make my decision whether or not I'm gonna get involved. This lady I've never seen her. So, I mean,
no,
and we're trying to do the right thing, but it's been a year now, I think. More than a year.
11 months.
Trying to get a permit to do anything. I mean, we can use the building as it is and turn it into a junkyard like it was, no problem. I got the permits for that. Not a junkyard, I mean, a visual junkyard.
No, I'm just procedurally trying to sift out what this board has the authority to rule on and what it does.
We're not looking for anything out there.
Understood.
What we put in writing on our building permit application, if we decide to do more, of course, we'll have to come back and do it again. But right now, I think it's been 18 months. By the way, I had everything ready in a package, wetlands, septic, water, everything, right? Federal government. And in the interim, the rules changed. Where does that leave me?
And this,
And I paid a water bill for 3 years and didn't have a water meter.
but the current use, which is contractor storage, is just gonna be the continuation of the use that is affixed to this building permit. Like Mr. Sindrich said, if they were to do something down the road, and development plan review was required, be more than happy to come back here, be more than happy to comply with it. It's just not what is before this board tonight.
All right. I mean, it doesn't seem like too much of a factual dispute. It seems like a legal dispute as to what's required here. Give Mr. Cozzolino an opportunity to ask questions. What we haven't heard yet is whether it's to council or Mr. Jordan himself, the position that was taken by the zoning official.
However the board would want, I could question him, or if you would rather have him give a narrative.
I'll defer to Mr. Cozzolino. If you want to give us a narrative, of course, Mr. Ardenti would reserve the right to ask the zoning official directly. I think that expedites things and is fair to all unless there's an issue that a party has.
Well, I'll ask him some
Okay,
open
sure.
questions and then I'm
Fine.
gonna swear.
I just, for consistency purposes, Mr. Jordan, do you just raise your right hand, please? Do you swear to tell the truth, the whole truth, nothing but the truth here this evening?
I do.
Very good. Mr. Cozzolino.
Mr. Jordan, you're the town zoning inspector, is that correct?
Yes.
And how long have you had such a position?
Year and a half? 2 years?
My 2-year anniversary is coming up.
Oh.
For me.
3 years?
Just let him, just let him
Sorry.
answer on his own.
Yeah, okay, yeah, so probably 3 years.
And it's certain, Mr. Sindrich at some point filed a plan with the town, is that correct?
I do believe so, yes.
And how did-
So when a plan comes in, it usually goes to building, zoning, and planning under the new state viewpoint, under viewpoint, it goes to everybody at the same time. So
And what was your understanding of the layout of this property?
it was, I mean, the only thing that was different is it was going up in one section. That was all it was. But then I guess there was something, was there expansion on the back or something? Was there a deck or something that was?
All got
supposed to
taken
be set?
off. It all got taken off.
Oh, okay. Yeah, so what I'm saying, when it all came in.
The first application, yeah.
Yeah. Yeah. That was specifically for the fire marshal. Okay. I have a fire permit too. I had to tell him, they won't let me do it. Let's find another way. So we recessed the second means of egress into the building, inside the same footprint, so that they can do it. His only request up there was fire extinguishers. Yeah. But I mean, as
And
far
what
as,
what was your understanding of the use?
as it was, I mean, they were using it as construction or storage or whatever was going on.
And what is it zoned?
General business.
And it's in the aquifer overlay district, is that correct?
Yeah, the town adopted the Aquifer Overlay District 3 years ago, I think. Yeah, about 3 years ago they adopted it.
You don't take a position regarding development plan review or anything like that, is that correct?
Nope.
Your sole duty is to determine
If
whether,
the- yeah.
whether,
If the planning board would have a question for me, that'd be the only.
right, but
thing I would have to deal with.
your duty is to determine whether or not you need any.
Yep.
And you made a determination that a special use permit was required in this aquifer overlay district, is that correct?
Yes,
And why did you make that? What brought you to that determination?
because if you go to the use code table, if you go all the way to the end where the Aquifer Overlay Districts are, whether it's in A or B, it'll tell you whether you need a special use permit.
So you found this to be an expansion of an existing use, correct?
Yes, yeah.
And regarding the aquifer overlay, is there a specific criteria required in that district? for
There's
any-
certain things that they want. They just want to know, on the drawing, you have to have like a catch basin inside in case you have any chemicals in there. Any sinks or anything have to go to an oil separator. There's some minor things that gotta be done with it. It's all just safety stuff to make sure no chemicals get in the ground.
And in your opinion, would you have an objection to a special use permit based upon those plans that criteria is met?
Yeah, not at all.
can you repeat the last question? I'm sorry.
Whether he felt if that criteria was met, he would have any objection to issuing a special use permit. It was not.
Thank you. All right, Mr. Jordan, you said that there was some you said that there was some criteria to the special use permit, the Aquifer Overlayer District.
Yep.
Is that criteria, triggering in the sense that you have to meet those items prior to applying to the special use permit? Or are those part and parcel to after the application?
You would have to draw it on, you'd have to show the board for the obviously, when you go for a special use permit, you're gonna have to draw it on the plan, what you're gonna do to meet those certain things.
Okay, do you know where in the zoning code it says that?
It's in the aquifer, it's 1821, I do believe, the aquifer overlay district. It's got-
1821-060?
It's the whole thing. I mean, you got 8050, you have development standards, floor drains, indoor storage of hazardous materials, outdoor storage of hazardous materials, loading areas, dumpsters, exterior catch basins, underground storage tanks, above ground storage tanks. That 60 is DPR. That's changes in nature or intensity of the land. That's if it would have to go to DPR if you were intensifying the what was it? Accessory use of the permitted array except single family detached. It's the whole, everything is in that whole section to tell you what you would or wouldn't have to do.
Okay, but are any of those attached to the actual special use permit? Or is that just the development process for developments within the?
That's to get the special use permit. That's what it's telling you. You're gonna have to seek a special use permit for that. You're gonna have to show the board that you're gonna not pollute the property.
But are these requirements for all special use permits that are listed?
In the aquifer overlay, if you go on, if you go on the use
Wait a minute,
code, if you go on the use codes, it shows you under aquifer overlay district A or B, if you need the special use permit for that use code. There's a lot of use codes that don't need it.
My question is though, these requirements that you listed in the aquifer protection overlay district that you claim are attached to that special use permit, do those differ between each special use permit within that aquifer zoning overlay district? Or is it just if you need a special use permit for any use in the aquifer, you're subject to these requirements?
No, there's only certain ones that that are marked, that need a special use permit. In the whole, they're all marked, every use code, look at the end of it, and if you need a special use permit, it tells you.
I understand that. My question is, all special use permits for aquifer overlay district. So if you are in the aquifer and you need a special use permit, let's pretend Mr. Sinrich needs special use for contractor trade, and I need special use, let's make something up, I need special use for multifamily and residential district or whatever. Do the requirements that you listed change at all between our two special use permits if we're located in the aquifer overlay?
It all depends on if you need it or not. I mean, like
No,
this
no.
aquifer overlay A, you might not need it if you're in the A district or the B district. Some are double.
If we're both in the B district, same set of facts that I just gave,
Yep.
do the requirements change at all between the special use permits?
You gotta go by chapter 18.21. It all depends on what you're doing. I mean, if you're not gonna have any if you're not gonna have any chemicals there, you're not gonna have any of that stuff. Obviously, you don't have to put any of that stuff on your special, you're gonna do it.
But
Mr. Ardent, maybe, I think I know what you're saying. I'm gonna ask this question maybe to help myself. You're saying, with all things being equal, you are in the same zone with two separate uses. Are there specific criteria for each respective use by which the fulfillment of those conditions can entitle you to a special use permit?
I'm going to incorporate Mr.
And it
Sinrach's
wasn't,
question.
and it was a very ugly way of saying it, but I think I was able to get my head around.
Yes.
So everything being equal, different uses requiring a special use permit. Do those uses have specific criteria tailored to the uses? Is that what you're trying to say?
Correct.
And maybe what I'm trying to say.
I guess not. It's all blanketed under the whole chapter.
Thank you. Okay, next question. You said earlier that you took no position on whether Mr. Sinrich would need development plan review or not.
Yeah, as of right now, no, it's got nothing to do with me.
Okay. Is this a true and accurate copy of your zoning determination?
Yes.
Can you read what you wrote in the box, please?
Use code 602 is
Just
permitted.
slowly, please.
Use code 602 is permitted in the general business zone. plat 4A, lot 1-001, falls in the APOD, Aquifer Protection Overlay District, Subdistrict B. So it would have to have a special use permit under 18.16 table and would have to comply with chapter 18.21 of the zoning ordinance.
And can you read what 18.21.060 says at the top, the title?
Development plan review.
Thank you. All right, next and final question. You had mentioned earlier that your duties on this and your determination were completely separate from the planners, correct?
Yes.
Okay. I'm going to read into the record an email from the planner, which was sent to Mr. Sinrich prior to us requesting a zoning determination. I'm going to read relevant parts and keep away from the rest. Please submit a development plan review application for the subject site.
Same thing, please slow down.
Please submit a development plan review application for the subject site. And I'm going to jump further into the email. As a result, a special use permit would be required in conjunction with the additional requirements associated with development. Now, Mr. Jordan.
That's what I was.
In reviewing your determination, which was the exact statements as the planners, after we had consulted with the planner, but before we consulted with you, would you say that your determination was wholly separate of the planner?
As far as the zoning, the DPR, I guess it looks like it would, because you'd have to follow through on all that stuff that's last within it.
Thank you for clarification. Are you talking about the September 5th, 2024 email from,
It was attached as Exhibit A to my initial correspondence to Mr. Jordan. It would be September 5th, 2020.
and was that when she was recommending that it was a mixed-use building? Is that when the original plan was for apartments?
Well, we had changed it at that point. She was still under the impression it was mixed use.
Even though you told her it was not, and
Excuse me, it's zoned mixed use in your manual. I don't understand why you have a manual that spells out what you can do in each and every town, and you get there to do it, you can't do it. That's why nothing happens.
No further questions from Mr.
Thank you. Mr. Cozzolino, anything else?
I would just instruct the board not to give a lot of weight to the email without having Ms. Gillette here to explain her position. Other than that, I have no question.
Yeah, I mean, I think we'll give it whatever weight it's due. I understood the point by council, you know. We've been kind of informal tonight, also formal at times. I want to make sure everybody has had an opportunity to say everything they wanted to say. Mr. Ardenti, anything else, as far as presenting evidence to the board?
Nothing further from me, Mr. Chairman. Thank the board for their time.
Great. Mr. Cozzolino. Mr. Zangari. And I'll add to that, what to do.
All right. Couple of issues. So you have before you, I think, and you should have a copy of Mr. Jordan's zoning determination, right? 'Cause that's what you're ruling on tonight. Maybe let's focus on that. And then, as I see it, and you can disagree with me, Mr. Solitro, members of the board, but I see there's two things there, right? First one is whether or not special use permit is required. And whether, because of the expansion, and whether or not whether or not a special use permit is required because they're in the Aquifer Protection Overlay District, and whether or not there is development plan review required. So I would make a suggestion as to the second, right, the development plan review. If you look at the ordinance, the town ordinance is 182160. In the first paragraph A, the purpose of development plan review of uses in the Aquifer Overlay Protection District. It's where we are, we're in the APOD. is to ensure that all changes in the nature and intensity of land uses are designed and constructed in a way that will minimize the impact on the aquifer. So I think the first question is there a change in use based on the evidence you've heard from the applicant, from Mr. Jordan, and all the evidence submitted, the demonstrative evidence, right? The documents in your package. That might be the first issue. Is there a change in use that would trigger the development plan review? Second part of that is the purpose of it was regarding change in the use, in the nature, and the intensity. Is there a change in the intensity? He's doing storage before and he's doing storage now. Is an expansion of the storage to the second floor. Is that an intensification in your mind based on the evidence you've heard? That might be the second question you consider. Going back to the first one, the special use permit. Mr. Ardente, a counsel for the applicant, quotes the general law. His reading of it is accurate. I pulled it up on my computer and I checked. He is accurate when he says the state law requires specific criteria for each use, as you very well delineated,
It was a
Mr.
mess,
Salitra.
but it was a. oh, I
It wa-
didn't-
Well,
It was very
a little bit.
good.
No, but it got to the heart of it. And I think we both agree, got to the heart of it is, okay, for this particular use, is there a specific criteria? That is a requirement under the new law, right? Which was, I think, enacted just before this is perking up. Right? So it was new at the time, certainly. Still pretty new, but very new. So that might be the other thing you consider. The second the second part of that you might consider in your analysis is what Mr. Jordan got into with regard to whether or not those special use criteria are listed in the ordinance, under the APOD ordinance, 1821. He listed and he went under 1821 development standards, and it's pretty specific. Now, whether or not that satisfied the specificity of the statute, as Mr. Ardente has argued and you've articulated, that's going to be a question for you to determine, right? I'm not saying that's an easy one to determine, but that's what I think that's what you need to do. Right? So that's kind of the way I would advise you to approach it. And obviously you would make a finding of fact as to both of those things. And you'll need 3 out of 5 to vote in the affirmative, whichever way you decide. You need 3, a simple majority.
I have a question. So, Mr. Ardente, so with the change in the state law, it is your thought, practice, advice to your own clients that a town council for each and every special use permit that is required in its use table, they have specific and articulable criteria for each one of those. And I suppose that's the question.
Yes,
Okay.
that's correct. So we just, like I said, I
Right,
work
right.
for zoning and planning in Central Falls as their solicitor. Off record, not a part of this, I would be happy to send our newest ordinance to the board so they can kind of get an idea of what should be done in the use table to update that to come into conformance with state law. Yeah, I mean, every town that we're working with right now, and we've been getting grants from RIMFAC, and you're more than welcome to go check Rhode Island. What does RIMFAC stand for?
Rhode Island Housing.
Rhode Island Housing. You can go check on Rhode Island Housing's website, and they actually have templates that they provide to each town to update the specific and objective criteria portions of each special use permit. That's the way that the General Assembly has expressed it should be done. And that's the way that the towns who are making efforts to come into conformance with that requirement are doing it. As Mr. Zangari said, this is very new, so I don't fault the board or anyone for not having each special use permit have specific and objective criteria. This only went into effect January 1st, 2024. This is very new. But that's my position with that.
Can we hear from your client as to the intensification of the use, whether it's being expanded, modified, intensified in any manner?
The only change would be we may move an office up there. That's it. Basically, it's storage inside of construction material, mainly, and tools and equipment. That's what a contractor's yard is. We have heavy equipment, we have all that, but that wouldn't go there. That goes to our property in West Kingston, where it's safer and no kids. We have a lot of kid problems up there. You know, the police, we've been in touch with them several times for kids messing around up there, but it's indoor. It'll basically, I would say, look like it's a vacant building, beautiful vacant building.
Mr. President, would it be helpful to, if Mr. Cindric gave you a little more detail on it, if that expansion is just going to be an office?
Absolutely. I want to hear it all. And
Yeah.
Chris,
At this time, it probably will not be an office, because we have an office in the nice office on our property, but it's kind of hard. We change our track and start meeting with clients. It'd be better to have a commercial location.
Or
We don't see that in the near future.
or what might be stored in the new storage area?
sure, please.
No,
Stuff that you don't want to see, like tile, leftover materials, valuable light fixtures, whatever. Put it up.
And how big is this?
I believe it's, the addition part's 20 by 25, maybe,
It's 900 square.
900
so
square.
no
feet.
chemicals.
Building is 2,000. We have a loading dock that was, I think it's 14 by 60. And we have permits to rebuild. We have permits to rebuild all the sluice gates and all the stonework on the whole property. The property is, by the way, I had to buy more land off of Woodmansee to make everything work, the septic system and all that. I had to buy another half acre. So then we have 3 acres or 3.5 acres there.
Where are you gonna store up there?
In the building?
Yeah.
Basically interior construction material, no yard storage, because it's not a big piece of property. Most of the land, 2 acres of it is an island, which we have a permit for a footbridge to go on it from DEM. Because it's on the river, fishing, people are always fishing there, whatever. My insurance people are on board with that use, you can let them go in there, but if you let them and give permission, you have to sign a waiver or whatever. But we have no intention of storing stuff on the property itself outside. Nothing.
Any paint or chemicals upstairs?
Excuse me?
Any paint or chemicals stored upstairs?
No, we don't do that kind of, we have contractors, but having said that, I mean, you have the local hardware store with thousands of gallons of paint. And
Yeah.
someday they're gonna want to change their awning and they're gonna have to go through the same stuff, because that's a change in, according to your planner, that's a change of use. If they wanted to put an awning out front, keep their peat moss under, change of use. Same difference. So we're just stuck in the middle of this, whatever you want. To this date, we've given the state, the town, everything they wanted, and then we hit this stumbling block. I mean, it was, I don't know.
Mr. Cozzolino, I'm putting you on the spot and I hate to do it. Do you have a position as to what Mr. Ardente and I have been going back and forth about this, change in the law? We're all trying to figure this out with the General Assembly changing land use and zoning laws in the past couple of years. With respect to cities and towns requiring specific and articulable criteria for each and every special use permit. This is the first time I've dealt with it, frankly. So I'm trying to figure it out on the fly. I'm putting you on the spot as to whether or not you have a position on that.
The issues I've seen where that's come up is in a general zoning district. What makes this, the little twist on this is that it's on an aquifer overlay. So there's an additional layer of protection that is required because it's to protect the water source. So I haven't specifically run across that extra layer. But I do agree with him that in general, if you have a specific use and you want to restrict it, you have to restrict it. But like I said, in the aquifer overlay, it's a more environmentally sensitive area. That's why they cut it out to an section and the B section where the uses, whatever you fall into, there is specific criteria.
Mr. Chairman,
Sure,
if I may, could I just read, this might be helpful.
please.
I'm gonna read straight from the new law, which is subsection 3, which says, establish specific and objective criteria for the issuance of each type of use category, special use permit.
And an aquifer overlay district is not a use category.
No, that would be a district. Zoning district.
Any other questions? And to my friends on the board whose heads might be spinning, with you a bit.
I was just wondering, could you give me an example of what specific and objective criteria would be, and if it would be like a checklist they could just check off?
Yeah, so I gave an example earlier, perhaps I didn't explain it necessarily perfectly, but I recently did a development where I was the applicant in North Providence, and they had the correct version of the new special use permit requirement, where if you want their RG zone, it was in RG zone, to build multifamily housing, which that was the qualifier, multifamily, there was 2 qualifiers, but to build multifamily housing, they allowed it under special use permit. It was limited to 2-family dwellings and 8,500 square foot lots, or something like that. The measurement, I don't think I got exactly correct on that, but it had a measurement associated with it. But those 2 things were specific to that use in that zone, right? So if you want to go RG and you want to do you want to do multifamily, you're gonna be limited to 2-family, and you need this size lot to do it.
So we have very much a legal question before the board based on very new state law. Personally, I do this for a living and I'm struggling with it. I trust the other board members are in a similar boat, if not worse off. Mr. Ardente submitted to us, it's in the form of a letter, but he did an excellent job laying out a number of the issues. I don't want to give out homework assignments, but would it be of assistance to the board if we had Mr. Zangari or Mr. Cozzolino put their positions in writing so that members of the board could sit down, study this, and make a decision? Because I'm looking at some of the looks around the room as well as my own thoughts, and this is tough. Personally, I got a lot of clarity in the last couple minutes with respect to, let's see here, the fact that this is a aquifer overlay district, and the new state law requires specific and objective criteria with respect to each and every use. Made sense up here, but out loud, it's getting murky. What do we think about steps moving forward so that we can make an educated and informed decision for this applicant? Go ahead.
Yeah, I've read this 18-21 multiple times. I'm still trying to grasp of, with the overlay district. It's difficult.
I'm also sympathetic to an applicant who wants to move forward with, frankly, his life.
Yeah,
No
it's,
kidding, yeah.
Right.
yeah, I mean, it's almost 100-year-old building.
Through these hoops.
Yeah.
Yeah, it's, just what, like 25 by 20, second floor.
Yes.
I walked by it about a week ago.
That-
I was
that
over
piece
there
of-
looking at it.
That piece of property is the start of Richmond, Rhode Island. It was Brand Ironworks in 17 something. The sluice gates we're rebuilding are original to the property.
Yeah, I was looking at it about a week ago.
It's a cool place, but.
And Mr. Chairman pointed out, and he's correct, but I just want to make sure that all the board members understand it. We're looking at 2 separate categories, right? We're looking at use category and zoning district category. The aquifer is a zoning district category. So that, the aquifer is a zoning district category. We're talking about the use, which is contractor storage. The state law that clarifies the specific and objective criteria for special use permit is required for uses. So essentially, if you can't just broad sweep a district, right? It doesn't say district in the statute. So I hope that was helpful in determining difference, what we're dealing with here with
A little
the,
bit.
yeah, use versus district.
I know we're still struggling with it to understand, not only understand what to do, but understand what the issues are. I'm speaking for everybody, but that seems to be the consensus here, unless somebody wants to tell me otherwise.
Yeah. That's what
Um,
it sounds like.
And what I had said a moment ago, I also don't like kicking the can down the road, even to March, where this gentleman wants to move forward with his business in town.
Boilerplate, has the use changed? I think that's the underlying
No.
question right there.
No, it's the same use.
So if the use hasn't changed,
So Chris, should we close, how do we want to proceed? I want to discuss this amongst the board. I also, as much as the lawyers who are friends of mine in this room are going to yell at me that we may dish out a homework assignment, I know. I also want to leave open the opportunity where we hear from council. I've heard from Mr. Ardente, did a great job, laid it out, provided more clarity tonight. Frankly, some of it is what say the zoning official in response to that, in response to what we've had clarified tonight. All the meanwhile, I want to make sure my board members are on the same page as where I think I am. Do we keep the hearing open? Do we close it for a discussion and then decide what we want to do?
You could certainly,
I don't have notes that you've opened it. Do you have notes that it was opened?
I think she's talking about the public hearing.
yeah,
Public hearing?
yeah,
Oh, okay.
the public hearings, though.
Yeah.
Okay.
That's what we're doing, yeah. You can keep it open for further discussion. You could, if all the testimony is in, all the arguments are in, you could close it, have your discussion, and then ask for submittal of briefs. And then you'd make a decision at your next meeting in 2 weeks or 1 month.
February.
It's 1 month.
I think that makes sense. I'd like to have a discussion right now.
Have a discussion.
I am not going to use the word brief, but if it is notes, bullet points, ideas, concepts, email, of course, submitted appropriately before the board and CC the council. That would be good. It doesn't have to be formal. I want to know everybody's position and I want them to explain it to the board. Mr. Ardente, homework may already be done. Who wants to, do we want, that being said, we want to have a discussion right now for a few moments as to where we're at and what our thoughts are.
Yeah.
What do you think?
yes.
All right, so,
Yes.
is it, should we close, do we have to close the public hearing?
You don't have
We
to, but you certainly could.
If you close a public hearing, then you can no longer take any
That's
testimony,
right.
ask any questions of anyone.
But we could still accept what
You
our
can accept,
position.
yeah, accept submission, but if you want to leave it open, if the
Just so we leave
submissions
it
raise
open.
more questions, you may want
Okay.
to follow up at the next meeting with whoever submitted it or additional.
He can
evidence.
still ask questions of me if the public meeting, if the public hearing portion is closed.
We don't have a line going outside. I don't see any harm in keeping it open. It's right.
Go ahead.
and nobody's coming in with a smoking gun on this issue. It is what it is. So I'm good with keeping it open. Everybody else.
I'm good with
Yeah,
keeping it
all right,
open.
let's have a discussion right now. Where we at?
Okay, my previous comment was, I think we need to focus, for me, the boilerplate issue, as I said, the use hasn't changed. I think we need to deviate and build upon that. If the use hasn't changed, the rest of it, not a lawyer,
Lucky
somebody
you.
help me out here.
So to Chris's list, and by the way, this is the reason I brought a computer tonight, and I've never brought them before, just so I can write all this stuff down. Chris gave us two issues. One is a special use permit required. Two is DPR required.
And then I think what I said was, addressing what may be the easier one to decide first, which is development plan review.
And please correct me if I'm wrong on this. If there is no change in use or no change in intensification of use, DPR is not required?
That's correct.
Okay.
So if you should come to that determination, based on your findings of fact, then that portion of the zoning determination, you would reverse, if that's what you would.
Where are you on that? Has the use changed? Has it been intensified? And honestly, I mean, the board general.
Obviously, there's more square footage, so it's going to intensify, I think, minimally. Are we allowed, I mean, what constitutes substantial change? If we're only adding a few hundred square feet and a few shelving units upstairs, is it significant?
That's not what the ordinance doesn't talk about significant or substantial. It just talks about, it talks about intensity, right? So changes in the nature and intensity.
But we didn't hear testimony, okay, I'm bringing in more trucks of supplies. It sounds like it may remain the same intensity. He just has more room to do his stuff.
900 square feet. I believe it was.
But
Whatever that
going up,
was.
it's
Yeah,
not
it was-
going
it's
out,
900
it's
square feet.
Staying within.
It's not, I'm expanding my business to take in 2 more truckloads of construction materials. It's, I have more room to continue doing what I was doing. That may be a way to deal with intensity.
And it's only
I-
a portion of the second,
Yeah, it's 20 by 25 feet.
yeah, 900
So-
square feet.
We have a straw poll, if you will. On
Barely larger than a one-car garage.
Yeah.
Correct, virtually.
We have, all right, so we have general consensus on that. Then we have, is a special use permit required? Chris, correct me if I'm wrong, where we now have this change of law. So the change in the law requires specific and objective criteria for the issuance of each use category of special use permit. Follow that down. If an ordinance does not expressly provide for specific and objective criteria for the issuance of a category of special use permit, such category shall be deemed permitted. So if an ordinance, how I read this, if an ordinance doesn't provide those specific and objective criteria for a category of special use permit, then that category is deemed permitted. If you don't have these specific criteria for this type of use, the gas station, if there's gonna be a gas station in town, you need to do X, Y, and Z. If the ordinance doesn't specifically state the criteria required
Yeah.
for a gas station, then it's permitted. Forget the special use permit. That's how I read it. Chris, is that how you read this as well?
I'm looking at right now at 45,
2442.
25, strike that. Rhode Island General Law 45, 24, 42, titled General Provisions, hyphen Special Use Permits. And I'm just looking at, and Mr. Ardenti, you know which specific subpart of B it says, if you don't,
I read
That would be,
B3 and then the last part, C.
yeah, C. Could be on the second page. I don't know if it's on pages on there, but it'd be towards the bottom.
okay, and it is subsection C of the ordinance. I'll read it. If an ordinance does not expressly provide for specific and objective criteria for the issuance of a category of special use permit, such category shall be deemed, strike that, shall be deemed to be permitted use. So you are correct.
If an ordinance doesn't provide these specific criteria, then forget about the requirement of a special use in the ordinance. It's permitted now.
And I'm looking that up. That is effective as of June 25th, 2024.
Just over, in its infancy is where this is.
And that's applicable to the aquifer overlay.
It's applicable to special use permit requirements, whether or not it's, I would advise it, whether or not it's in an aquifer overlay district. So it has to do with uses.
And an aquifer overlay district is not a use. Mr. Jordan pointed to specific criteria for the aquifer overlay district, but those criteria are not for a use, it's for the district itself.
Mr. Chairman. I don't know if you want to hear this. I actually have something helpful here that kind of fell directly into your example of gas stations. RIMFAC has templates that we've been using, like I said, to update the codes. They actually have one for gas stations that would meet the specific and objective criteria.
What type of criteria?
So gas stations, Two, gas station, section 1, gas station shall meet the following minimum lot requirements. Lot area of insert number of square feet, lot depth of insert number of square feet, and lot width of insert number of feet. Structures and all, number 2, structures and all pump islands, compressed air connections, and similar equipment shall be set back at a minimum of blank feet from side and rear lot lines. Number 3, no access driveway may exceed blank number of feet, blah, blah, blah. Number 5, underground tanks shall meet all the following requirements: maximum storage capacity for petroleum products, insert gallons, amount of the tank. And it goes on and on and on. Electrical vehicle charging stations may be included as an accessory use to the gas station, may not be counted toward parking.
So specific criteria related to gas.
Yes,
Um,
and that's right. I can send that to Attorney Zangari, that template.
please,
Not to throw another hand grenade on the. pot.
why not?
The other question that you have to face is, even if you find they don't need a special use permit, I think the position of the zoning officers, they still have to comply with the requirements of the Aquifer Overlay District.
And we haven't talked about that tonight. Has that been contemplated by the appellant, or do you have a position on that?
The position is that well, this is the first the applicants heard of the Aquifer Overlay District. But the important thing to note about the aquifer is that the planner's position and the code's position, that if you need a special use permit under the aquifer, that is the triggering mechanism for the requirements of the Aquifer Overlay District.
And you're saying because there isn't specific and articulable criteria for this use, it's a permitted use and you don't have to comply with it.
Correct. And you could even go so far as to say, to throw another hand grenade on it. We would essentially resort back to the base zoning district, which is GB, which this is permitted as of right with no special conditions.
That ignores the Aquifer zoning district.
It does. Because if you look at 182150, the development standards, it says all new structures in the overlay district and all renovations of existing structures in the overlay district for which a building permit is required shall comply with the following standards. And then it goes A through I.
Sure, the 182150, you said?
Yes.
All right.
But I think, Mr. Chairman, the entire, and I commend the town for the Aquifer Overlay District. I think it was just enacted a little too late in terms of, a little too soon, where this was enacted before the new law. So the Aquifer Overlay, in order for this to trigger, the special use permit would have to be triggered, right? Because that's the whole purpose, if you read the Aquifer Overlay District, is to comply with that special use. In fact, it says in that chapter, it mentions that if the use is permitted in the base overlay district, but it's a special use permit within the aquifer is going to control. So essentially, the special use permit is your ticket into the requirements for the aquifer. If the special use permit is not operative, then none of the portions of the Aquifer Overlay or District Code can be used against the applicant in this case. Right, because how else would you qualify?
What part of the out of the ordinance out of 1821? Start Dente. How did you? Where are you seeing the requirement for a special use permit to trigger?
I think he's talking the use table.
Use table.
Oh, it's okay.
Yeah, use table. So the use table is triggering, and then if you go to 1821-20C, uses permitted, allowed by special use permit, and prohibited in each sub-district are shall. No, that's not good. I just. Oh, B, excuse me. The requirements applicable to the overlay district are in addition to those of the underlying zoning district. They case of a conflict between the requirements of the overlay district and those of the underlying zoning district, the more restrictive requirements shall apply. The problem here is that the dimension, excuse me, not dimension, the use table itself is what provides for the special permit in District B. That's no longer operative. The ultimate issue, this was put on the books before the new law,
Right,
Yeah.
a year or so before the law was.
is really what this boils down to.
All right, where we at?
Richmond, Rhode Island.
Yeah, that's, Mike, what do you think? What do you want to do? You want an opportunity to address some of these issues?
Yeah, it's the aquifer thing throws a little wrinkle into the analysis for sure.
And part of my thought, which may be pertinent to this board, not that we don't try to do our due diligence, but however we decide this issue, especially if it's, the town has problems with respect to its aquifer overlay, an appeal could be taken by either party. We could have the town appealing. So I certainly want to do our due diligence. Again, we try to do that anyway. So my thought would be to continue this to a date certain, next month's agenda. Any of the parties are free to submit whatever they deem appropriate to this board. I'd suggest if it's appropriate, in advance, I maybe go through Ms. Hawkins, the clerk, and it can be then forwarded onto the board or CCing council with any submissions that you make. That way, again, we can do our homework. We want to make the right decision. I have a knee-jerk reaction to where I'm at. I think a number of members of the board may be in the same place. But there's a lot of moving parts. New law, frankly, is confusing. I don't want to put anybody in a situation where you're forced to judgment without thinking this through. And you might have the board at home with all the pieces of paper pasted up. Chris?
Could we take a 3-minute break? I'd like
Please.
to talk to
That's
council.
a great idea.
Maybe we can. Yeah, thank you.
Great, no, please, we can go off Back on the record, where are we?
I think Mr. Ardenti may have a request.
Sure.
So, our request before the board tonight, rather than drag this out and create more legal issues than we need to, in this case, the board has the power to remand and or modify the zoning enforcement officer's decision. So what we're requesting is a vote tonight to modify the decision to get rid of the requirement for development plan review based on our arguments. And rather than apply and obtain a special use permit, make the conditions expressed in the development standards of the aquifer overlay district in 18.21050 A through I, make those a condition of the grant of our building.
In that, all right, so Dane, sorry, can you just walk me through that? I just want to make sure I get it all down. Go
Yep,
ahead.
so it'd be a, let's just call it a modification of the zoning enforcement officer's decision. It would be a modification that development plan review is not required for this application for the proposal under the building permit. And no special use permit, but the applicant will comply as a condition of issuance of the building permit with those conditions referenced in 18.21.4050 A through I.
And are those the aquifer overlay district conditions?
Yes, and by compliance, I mean, if there are items that would apply, the applicant would agree to come in conformance with those, but some of these requirements would not be applicable, which the applicant would just express don't apply to this application and be confirmed by the zoning official as well.
Okay, and that is acceptable to the zoning official and council?
I have spoke with him and we think it's a good resolution because it provides a town with the act for overlay protection, but still allows that the application will meet the spirit of the law insofar as granting them the right to do what they want to do.
And maybe would we add to that, that request by Mr. Ardente, that the compliance with 182150 A through I, whether or not the compliance was met would be the determination of Mr. Jordan, at Mr. Jordan's discretion.
The form of documentation or affidavit or however you want to respond to those specific requirements.
Okay. Is that acceptable?
Would it be Mr. Jordan, the building inspector? At that point,
Oh, it's, Mr. Casalino, should it be Mr. Jordan or Mr. Santilli?
probably the building inspector.
It would attach to the building aspect of it.
So would it be
But I
Mr.
would-
Santilli?
Right, but I think we would still want it on the record here on the appeal next month.
So who makes the determination? Is it Mr. Santilli or Mr. Jordan?
As far as
The requirements.
It's gonna be drawn on the print and proposed to the zoning board to make sure, that's really what it is, I thought, but that's how we always did it before.
Well, they're gonna have a number of conditions that either apply or don't apply. If somebody, whether it be yourself or Mr. Santilli, said you didn't do this condition, or this condition applies and they say it doesn't apply, who's making that determination? Is it you, Josh, or is it Tony?
I mean, if it falls under zoning, so I mean, I don't know, I could do it, but.
All right.
It's in the
You're
zoning ordinance.
comfortable with Mr. Jordan making that determination?
Well, I have a quick suggestion because it popped into my mind as we were talking about this, who is responsible for administering anything that happens in the overlay district in terms of the requirements. I'm fine with that. According to this portion of the chapter, the zoning board is actually the one. who has-
That's what usually does, it gets,
I see.
it's put on the plan, you guys look just like the last one, the last landscaping one.
Then even better, any issues come back, right?
I'll let Mr.
Mr. Zangari.
So then where we're gonna leave it is, any issues, well, the determination of whether or not there's a compliance with A through I under the compliance portion of the ordinance for aquifer overlay protection. That will come back at the next meeting to the zoning board for review and determination for you to make a finding of fact. We're in agreement.
Okay. As this presents basically as a consent agreement that's being blessed by the zoning board, do you want specific findings with respect to DPR being required or not?
Yes,
I think we can deal with that issue tonight. All right.
yes, you should.
So, Steve, you have that paper that you had me read, the one that the one you had, yeah, that one, the zoning determination. Yep. The one you had.
You want a copy or?
No, I just want to see the one you had highlighted, yeah. Because I thought you read 18.21.60 for DP zoning plan review.
Or is this nowhere?
It's 1821, it's just a chapter, I didn't reference any specific. I didn't say you had to print it.
I do have it here somewhere.
I referenced the whole chapter.
Ah, there it is. Like you mentioned,
Just 18.21.
That's, you just mentioned, hold on.
Yeah, okay, yeah, because when you asked me, you asked about 18.21.60, I didn't say anything about having to go to DPR.
All right, so I suppose we close the public hearing. Is there a motion to close the public hearing?
I just had a question.
Oh, please.
I
Go
will.
ahead,
So is it gonna come back to the next zoning board meeting that we're gonna review this A through I?
Yeah.
And determine which ones apply to this application?
That was the request of the applicant.
Okay,
So we'll be determining that? We'll determine which ones he
You'll-
has to apply to. Oh,
No, you'll be determining whether or not they've complied with all of them.
and from
A
what
month's enough
I
time.
understand, some apply, some
Yeah.
may not.
right,
One
but
of the-
who's deciding which ones apply and which ones don't? Can we
You-
decide that?
Yes, you do. You'll,
Can we decide that tonight?
I would suggest let them
They
answer.
usually do theirs and then they propose it.
My suggestion would be that they comply with the requirements. If they feel that they do not need to comply with something because it just doesn't apply to them, they don't have hazardous materials, let's say, or they don't have a dumpster, and they're gonna tell you why it doesn't, I would hope, they would tell you why it doesn't apply, give their reasons. You'll digest those reasons and determine whether or not you're satisfied with that explanation. So yes, you will determine.
So for purposes, right now, procedurally, how are we proceeding? Are we not closing the public hearing?
You are keeping it open because you're gonna keep it open for next month.
If you've got questions, yeah.
Okay,
And I think what we're gonna do is, if you're inclined, you are going to take a vote on whether or not development plan review is required, because this portion of the determination says compliance with 1821. In 1821, part of it's development plan review. So if that falls within this determination, it does. It's a little broad. At least you can make that determination tonight.
So on the record, you're making a partial decision.
Right. So you would be, if you were to do that, you would be modifying in part. You'd make that modification. And then the other part would be the continuation till next month to make an approval of the building permit, subject to your approval of 1821-50 A through I.
all right. So we need all right, so we'll just go with a motion, as to the partial modification.
If that's what you want to do.
Okay. Well, I'll make the motion and we'll find out if the. Make sense?
Yes.
Okay.
So if the partial modification is a reversal of any requirement to to comply with development plan review. I think that's fair.
Be more of a clarification because it wasn't specifically set out in the zoning officer's determination.
Right, I heard Josh mention that a minute ago, you didn't cite exactly that section, but it came up tonight, so it's clarification, let's, with all due respect to Josh, we'll call it, my motion would be, we'll call it a reversal, but understanding you didn't cite that exact.
Have we addressed, the issuance of the actual building permit upon their findings, and if they have the power to issue as the zoning board?
No, they don't. They can only reverse, affirm, modify in whole or in part. So then it would, once you got, it would still, the application for the building permit would go through the normal process.
Would there be, the zoning board can make a positive recommendation, however, to the building department, I believe, based on the satisfaction of the conditions.
I don't know that it's on the agenda tonight. I don't know what that was not part of the appeal. I understand what you're
I think
asking.
the zoning board has jurisdiction.
I'm not
It's a
sure.
building issue.
I'm not sure they do either.
So, I'm prepared, I'll make a motion myself and we'll see where the board is at on it. All right. Make a motion to modify the decision of the zoning official with respect to whether or not development plan review is required. We heard testimony this evening from the appellant, which indicates a continuation of the same use. We heard no testimony that that use would in any way be intensified. On that basis, my motion would be to find that DPR, development plan review, is not required. And to the extent that that were part of the decision, albeit by implication, I would find that that is inappropriate in this circumstance. And DPR, again, is not required. To the other portion that we were discussing amongst the group, Chris, correct me if I'm wrong, that it'd be no special use permit, but there would be conditions of issuance of the zoning certificate.
Or as the town entitles it, a zoning determination.
We have zoning certificates too.
Okay.
That,
So is the applicant going to seek a zoning certificate or a determination?
You need that to get a building permit.
All right, so yes, that would be those.
there would be conditions placed by this board on the zoning determination.
No,
Or zoning-
certificate.
Yeah, they asked for a zoning determination originally, that's what that was. They'll need a zoning certificate that states that what they're doing is good to be done here.
All right. So, and they're going to now proceed and request that zoning certificate. Is that where we're at?
Once,
You can do it tomorrow. Yeah.
wait a minute, that would be after the conditions are either met or not met as determined by the board
Oh, I got you.
Right.
next month.
So further, with my motion, the conditions addressed in 1821-50, A through I, will be addressed as to their compliance and or applicability to this applicant by the zoning board at next month's meeting. Did I miss it?
No, but in
and-
your,
go
your
ahead.
motion, so you've got two things, you got two parts to your motion. I don't know, you don't know necessarily if everyone's going to be in
We'll
agreement. with
see if we
both
have a mixed
parts.
bag and
Okay.
somebody can make a separate motion. And I will add for the record, if it wasn't clear, that this is by agreement of the parties here this evening. Fair? Okay. That's my motion. Is there a second? And then we can have discussion.
I'll second.
Discussion. First of all, I thank you to all council for taking, you did promise 3 minutes, but it's longer than 3 minutes. I appreciate it.
Thank you.
I think, if I could speak, that we're trying to find the right solution to this, to do the right thing. I appreciate all parties putting a pause on it to see if a resolution can be had. Anything you guys want to add with respect to for the board?
Sounds like we'll satisfy the inquiries that we had and that, if we're gonna go through at the next meeting, and then we'll be determined on that, was it 18-50 A through I?
Yeah,
18,
2150.
I'm sorry, 18 dash 20.
Yes.
Um,
All right, anything else for discussion? All right, we have a motion second. We've had discussion. All in favor? Aye. The ayes have it. All right.
Thank you, Mr. Chairman.
Do we need a date certain for next month,
Yes.
which is?
February 24th.
24.
All right, so this matter will be continued to 2/24. You're taking a motion to continue this matter. Is there a motion to continue to 2/24?
Make a motion to continue to 2/24.
Motion, is there a second? Justin, second. All in favor? Aye. Ayes have it, 2/24. Aye. Thank you, Council.
Thank you.
Is there a motion to adjourn?
I'll make a motion to adjourn.
Second.
Motion second, all in favor?
Aye.
Aye.
Thanks, Mr. Green.